Hello, everyone, and welcome to this webinar in our series on investing in Africa. Today, we focus on data protection legislation across the continent, which has become quite a hot topic, not only in South Africa, but also around the region. I'm pleased to introduce you to a panel of colleagues from across ENS Africa offices today. To start off with Aisha Rambajun from Mauritius. Welcome, Aisha, and thanks for joining us.
Celia.
Ira Gunning from South Africa. And Patricia Mamuni from Ghana. And Rahima Simiyalo from Uganda. Welcome, ladies, and we look forward to an interesting discussion. I'm handing over to Ira, which will be leading the discussion with everyone. If you have any questions, please feel free to post that in the Q&A box. If there's time at the end of the session, we will kind of address your questions. Otherwise, we will revert to you afterwards. But enjoy this presentation. Thank you.
Thank you so much, Celia, and thank you so much, everybody, for joining us. As Celia mentioned, we are going to discuss data protection laws in the region. And as you can imagine, there are laws in each of these jurisdictions, and we're going to start off with the law in South Africa, and we're going to do a comparison with the law in the 3 other jurisdictions. So in South Africa, we've got the Protection of Personal Information Act. I call it POPI. We all used to call it POPI when it was being drafted about 15 years ago. But most people these days call it POPIA. It is our law that regulates data protection and privacy, and it kicked in on 1 July 2021. Now, I'm going to hand over to my colleagues to give you an idea of what would be the laws in their jurisdictions that regulate privacy and data protection. And Aisha, I'm going to hand over to you to tell us about the Mauritian law.
Thanks, Ira. So in Mauritius, we have the Data Protection Act 2017. It came into force in January 2018, replacing the old law that we had from back in 2004. It really is inspired by the EU GDPR, and a lot of it is taken from the GDPR, but it has been adapted to the Mauritian context with a few exceptions, such as the need for registration. The penalties and enforcement are different, but we can go through that as we go along.
Thank you. And then I'll hand over to Patricia. Patricia, please tell us about the law in Ghana.
Thank you, Ira. So data privacy in Ghana is a constitutional human right. So you find it in our 1992 constitution. But we also have a separate law, which is the Data Protection Act of Ghana, 2012, Act 843, which came into force in 2012. And as Aisha said, it's the same for Ghana. It's heavily tailored like the GDPR. At the time, it was the EU Data Protection Directive, which was replaced by the GDPR. So compliance with the GDPR means compliance with Ghanaian law.
Thanks so much, Patricia. Yes, and that is interesting because like with your law, our South African law, POPI, is also based on the old EU directive, which was obviously replaced by the GDPR. And the GDPR is, of course, that gold standard that everybody turns to. And for example, in our law, it does say that you must take international standards into consideration when you do interpret the legislation. So interesting to find out that it's the same in your case. Rahima, please tell us about the law in Uganda.
Thanks, Ira. The right to privacy has been part of our law since 1995, and that's when the constitution was enacted in Uganda. And then this constitutional right to privacy was then given effect with the enactment of the Data Protection and Privacy Act, which came into force in May 2019. And I think just as Mauritius, Ghana, and South Africa, the drafters of our DPPA were heavily guided by the GDPR. So there's lots of similarities, which I'm sure we're going to get into. Thank you, Ira.
What is quite interesting, Rima and all my colleagues, is that we haven't seen a GDPR adequacy decision yet for any of our jurisdictions. So even though our laws are based on the EU directive or the GDPR, and we all are saying it's very similar to the EU directive or the GDPR, we haven't seen a formal announcement yet that any of our laws are adequate. And that's going to bring me, and we are going to discuss the application of our laws and the nuances in our laws, but I want to start off with quite an important nuance as far as the South African POPI is concerned, and the GDPR and the old EU directive, and also compared to your legislation in your various jurisdictions, is the fact that POPI protects not only human being data, but it also protects personal information of juristic persons, such as our companies, without any threshold. So we don't have a threshold that small companies are protected, but large companies are not. Data subjects are defined to include human beings as well as companies. So that is one of the main differences between our law and the international standards. Patricia, is there anything that you want to highlight that makes your law quite unique?
Yes, Era. So one of the key points I want to mention is that our law applies only to natural persons. It does not apply to juristic persons like in South Africa. And so when you talk about protection of data privacy or protection of personal data, it only applies to human beings and living human beings. For that matter. There are also certain key differences in terms of Ghanaian data protection law and then the GDPR and some other jurisdictions in Africa. One of them is the requirement to register under our law. So once you're deemed as a data controller, you're required to register with our supervisory authority, which is the Data Protection Commission, as a data controller. And after registration, you're supposed to renew your registration every 2 years. So it's not a one-time registration, but after every 2 years, you have to register with the commission. Also in terms of the sanctions, and I think Aisha made some statements in relation to that. For the sanctions, we don't only have fines, we have custodial sentences. And I realized that under the GDPR, they do not have custodial sentences. There's only fines when there's a breach. A third point I would like to highlight is the timelines within which to notify or to inform the commission where there's a data breach. Under Ghanaian law, you need to inform the commission or the data subjects within a reasonable time. The law says reasonably practical time, but you realize that under other laws, I believe South Africa and other jurisdictions and the EU as well, there's a specific timeline of 72 hours after becoming aware of a breach. You need to inform the supervisory authority, but in Ghana, we have no such specific timelines. You need to do it within a reasonably practical time once you become aware of the breach. So these are some of the key differences that we have under our law in relation to other laws.
Thank you for that, Patricia. What's quite interesting in South Africa, we also don't have the 72-hour period that we have under the GDPR. It's also as soon as reasonably practicable or reasonably possible that we must notify our information regulator. But our regulators seem to have indicated that they're going to adopt the 72-hour period, which of course is not written into our law. Rajiva, do you want to tell us about the key differences between the Ugandan law and the GDPR and anything that stands out as far as your law is concerned, and whether you protect juristic persons or not?
Yeah, sure. Thank you very much. So interestingly, as Patricia was discussing the differences, all of these things actually what our law also provides. So the differences as highlighted by Patricia under Ghanaian law are very similar to the differences under Ugandan law. The first point is that we also protect only natural persons. So our law doesn't extend to juristic persons in the way that the South African law does. We also have a requirement for data processors and collectors and controllers to register with the Personal Data and Protection Office. Our registration is valid for 12 months and it's then renewable after 12 months. Just as Ghana, we also have custodial sentences. If you're caught in breach of the data protection and privacy law, then you could be exposed to up to 10 years of a prison sentence, which is also quite different from what's provided in the GDPR. Then when it comes to the fines, what I noted is that the fines under the GDPR are quite steep as compared to the fines under our data protection and privacy law. I think that under the GDPR, you could be a fine of up to about 20 million euros could be imposed. The maximum fine under the DPPA is, I think, 2% of gross annual turnover. And I think that if you compare the size, an average sized Ugandan company would typically be much smaller than a European company. So I think when it comes to the quantum of the fine, ours is much smaller than what's provided under the EU, the GDPR. And I think the final point relates to provisions around employee and employee relationship in the data privacy and protection context. I know that in some jurisdiction, there's express provisions on how you're going to manage the collection and processing in that context. We don't have express provisions under the DPPA. What then we do as advisors is to just basically get that broader concepts around data privacy and protection, and then try to fit them within the particular employer and employee problem that we're faced with. I think broadly speaking, those are the key highlights when it comes to our law. Thanks, Ira.
Thank you, Rahima. And Ayesha, before I turn to you to discuss the position under the Mauritian DPA, two comments that we have in the Q&A. First of all, the person has asked, what does an adequacy decision mean? Would an adequacy decision mean that our law is similar to the GDPR? Absolutely. It would be the European Commission giving us a stamp of approval, saying that the law in a jurisdiction is similar to the law in the EU, namely the GDPR, and that makes transborder transfers easier. So I just wanted to note that. And then somebody else also commented, Patricia, that they do like what you're saying about living human beings, and companies still try and use data protection laws to access information about deceased human beings, or to keep or protect that information of deceased human beings. Absolutely. In terms of our Protection of Personal Information Act, it only applies to living human beings or existing companies, which is quite interesting because the sister act to POPI, the Promotion of Access to Information Act, if you haven't noticed, the definition of personal information is slightly different, and it also includes deceased person information for, I think it's a period of 20 years. I haven't looked at that definition for a while, but it's quite interesting to see these nuances. Ayesha, do you want to tell us about the things that stand out in terms of the Mauritian DPA and whether you protect juristic person information, and must the person be alive to be protected under your law?
Unfortunately, yes. So it has to be a living individual. The law specifically speaks of living individuals. And at the same time, it caters for a number of the differences that Rahima, Patricia, and yourselves have spoken about. So in terms of the territorial scope, GDPR unfortunately applies to everyone, processors and controllers, and it has extraterritorial scope, whereas in Mauritius, it only applies to a controller and processor who is established in Mauritius. And if that controller or processor is not established in Mauritius, it has to be using equipment in Mauritius for processing of personal data. And also in terms of registration requirements, we do have a registration requirements both for processors and controllers, unlike the GDPR. And that registration is valid for a period of 3 years. There is also a mandatory requirement for the appointment of data protection officers, which we do not necessarily see under the GDPR, and it's restricted to certain specific nature of business where you have to appoint a data protection officer, whereas in Mauritius it's irrespective of those. The moment you are a controller or a processor, you have to designate a data protection officer. Also, in terms of enforcement, we kind of join Rahima's position in terms of having pretty low fines. Our fines do not exceed 200,000 rupees, and we also have custodial sentences of 5 years. And we do not have anything that is related to the turnover of a company. However, one specific thing that stands out in terms of enforcement is that our Data Protection Office does not have powers to impose fines. The fines have to be imposed by the court, so there is a prosecution that needs to happen before the courts before we can actually impose those fines.
Thank you so much, Ayesha. Let me just catch up with a few things that I haven't told you about our South African law. As far as mandatory registration requirements are concerned, we don't have to register what we call a responsible party or an operator. I see my colleagues, like the GDPR, terms call it by their more international names. So responsible party is called a controller, or and a processor is called an operator in terms of POPI. They don't have to be registered in South Africa. In certain instances, you may need prior authorization from our information regulator before you can process personal information. For example, if you send special personal information or information of children out of South Africa and you haven't ensured adequate safeguards for that information, and you have to appoint an information officer. So our data protection officer in South Africa is called the information officer. Must appoint one by default, the CEO, if you don't appoint one, and our information officer and deputy information officers must be registered with our information regulator. As far as enforcement action is concerned in terms of POPI, you can go to a South African jail for up to 10 years or get fined 10 million rand or both, but that is only for offences. So if you contravene provisions of POPI, general rule is our information regulator can give you an enforcement notice, and then non-compliance with the enforcement notice, if you don't appeal, that would be an offence, and that can result in the fines and the jail time. I also wanted to mention that there is potential for personal liability on our information officers. For example, if they in a grossly negligent manner fail to have a PIA manual, a Promotion Access to Information Act manual in place, or if they tell the company not to comply with an enforcement notice. Now, I think we have probably covered this so far in our discussion, but I just want to make sure that we make clear to everybody what is personal information or personal data in terms of the local legislation and what triggers the application of our legislation. In South Africa, personal information is defined as any information that relates to an identifiable living human being or an existing juristic person, such as a company. And then we've got a list, which is not a closed list, of things that could be personal information. And our act is triggered by the fact that you are processing personal information in South Africa. So not necessarily who the data subject is, but the fact that you are processing personal information in South Africa. And our act does then have extraterritorial reach, like the GDPR, because it doesn't matter whether your data controller or your responsible party is located in South Africa or not. I'll hand over to you, Rahima. Do you want to tell us about the definition of personal data and just to clarify when your legislation applies?
Yeah, sure. Thanks, Ira. So personal data is defined as any information from which a person can be identified. So we're talking identification information, education information, and then we also have another category referred to as special personal data. So that covers things like marital status, sexual orientation, religious beliefs. So, broadly speaking, that kind of data from which a person can be identified. And then when it comes to scope, I think ours is twofold. First, it covers any processing and collection activities within Uganda, so within the jurisdiction of Uganda. And also secondly, if they're done outside of Uganda, provided that they relate to a Ugandan citizen, our act will have extraterritorial jurisdiction and would also cover such processing and collection activities.
Thank you, Rima. Patricia, do you want to tell us about Ghana?
So personal data is simply data from which an individual can be identified. And I'll juxtapose it with special data. With special data, the elements are listed. So we have things such as race, such as religious beliefs, and it goes on and on. But for personal data itself, it's just any information that data subjects can be identified. And in terms of the application of our law, it applies to a data controller where the data controller is established within Ghana and processing data in Ghana. That's the first leg. There's a second leg as well, where the data controller is not in Ghana, but uses equipment or data processors who are doing processing within Ghana. And then the third leg is where the data is being processed in respect of information which comes from Ghana. So these are the three legs when it comes to application of our Act.
Thank you, Patricia. I think that's very clear. Aisha, will you tell us about the Mauritian DPA, please?
I think our definition under the law is quite wide, and just like Patricia mentioned earlier, it relates to any information relating to a data subject, and the data subject is that identifiable living individual, and it makes reference to identifiers such as names, identification number, the location of the person, physical, genetic, or any sort of factor such as economic, cultural, social identity of that individual. And the law actually does make specific reference to those. And in terms of the scope of application, as I mentioned earlier, the Mauritian DPA applies to controllers and processors who are in Mauritius, and in terms of data that is collected within Mauritius, it does not have the extraterritorial scope that some of the jurisdictions may have.
Thank you so much. And I think, Rahima, I think you did mention special personal data. Now, my next question is about the distinction between ordinary personal information or personal data and special personal information. Before I get to that, I see we had a comment or question in the chat, just to clarify who a data subject is in terms of the South African Protection of Personal Information Act. A data subject is, of course, the person to whom personal information relates, and then in the South African context, it is a living, identifiable human being or existing juristic person, such as a company. And may I ask you to please put your questions in the Q&A, that way we can respond to you directly after the session. Thank you so much. Now, as far as special personal information is concerned, in terms of the South African legislation, we certainly do get the special category of information. What does it mean when information is classified as special? It means it is extra stringently protected in terms of the law. And in South Africa specifically, it is difficult to process special personal information without consent. It's not impossible, but it becomes more difficult to process special personal information as opposed to ordinary personal information if you don't have consent. Now, special personal information, what is interesting for me in the South African context, is that it includes information about an alleged unlawful conduct or proceedings in regard to this alleged wrongful conduct. When you have criminal history, that is ordinary personal information. So if you do a police check on somebody and found that they were convicted of something, that's classified as ordinary personal information. But this alleged part turns it into special personal information and more heavily protected. Also information, biometric information, which we think includes facial images, CCTV cameras, probably voice recordings and so on, also very stringently protected in terms of South African law. And then, of course, information of children. And in South Africa, children are defined as those who haven't been declared competent and are under 18. I'll start with you again, Aisha. Do you want to tell us about special personal data in Mauritius, if it is regulated differently to ordinary personal information, please?
Thanks, Ira. In Mauritius, it's actually called the special categories of personal data. It used to be sensitive information before, and as you mentioned, and we do have the same type of protection for an alleged commission of an offense by a data subject, and it goes a step further. It also provides for any proceedings for an offense committed or alleged to have been committed by the data subject, and even the disposal of such proceedings is deemed to be sensitive personal data. Over and above that, the special categories of personal data relate to things like racial and ethnic origin, political opinions, religious beliefs, the membership of a trade union, physical and mental health information, sexual orientation, practices and preference. You also have biometric data, which includes facial images. In terms of this list, surprisingly, usually you would expect this type of information to be specifically regulated only in the law, but the law does provide the right to the Data Protection Commissioner to supplement this list as and when required. So the Data Protection Commissioner can come and add a new category of sensitive personal data to the special category. On top of that, in terms of the processing, it is quite restricted because we require the consent of the data subject. And the special categories of personal data can only be processed if it is necessary for lawful reasons. And we have a strict prohibition in terms of the automated processing, like for profiling, for example. We do not have the right to process this type of information because it doesn't allow for profiling under the law based on the special categories of personal data.
Thanks so much. And Rahima, I'm going to hand over to you.
Yes, thank you very much, Iris. So I think I'd already touched on the definition, what falls within the definition of special personal data. And I think just similar to Aisha, it's things relating to religious, philosophical, health status, medical records. But interestingly, when it comes to the controls around how special personal data is to be processed or controlled, I don't see very stringent restrictions under the DPPA, as compared to what you've said in the South African law. For example, special personal data, there's a requirement for consent, but there's also other legal bases within which special personal data can be collected. For example, it can be collected by an. So it says that collection or processing is required in exercise of an obligation of an employer or an employee. And then also collection and processing is permissible to satisfy legitimate activities of a data controller or data processor. So, again, you see that the language is a bit more permissive. And I think the one thing that we usually struggle with is try to understand what the legislators, were trying to achieve by creating this special category of data. If we don't see an extra, we don't see such stringent requirements when it comes to, what are you, how else are you supposed to, further protect this special personal data? I think that the position in Uganda is a little bit different from what you see, for example, in South Africa and Mauritius.
It sounds like it. And information of children, do you have a extra protection for children?
Yeah, so information relating to children, interestingly, is not under the category of special personal data. So there's a different provision to protect information relating to children. But even then, that's permissible, provided you get the consent of the guardian, the parent, or a person who has authority over this child. It's also permissible if you're doing it for statistical or research purposes. So, again, we don't see the very stringent controls around data relating to children or this special category of data.
That's very interesting. And Patricia, do you want to clarify for us in Ghana how special personal information and information of children are treated?
Yeah, thank you, Era. So special personal data is similar to what Aisha and I believe Rahima mentioned, and it relates to race, color, your political beliefs, your religious beliefs, your sexual orientation, proceedings for an offense committed or even alleged to have been committed, your tribal origin, anything about your ethnicity, all these are considered as special data. And similar to Uganda, and I believe Mauritius, you need the consent of the data subjects to be able to process this. If you compare this with personal data, not special personal data, just personal data, which I believe you mentioned ordinary personal data. We don't have that under our law, but it's similar to personal data. There are certain instances where you do not have to seek the consent of the data subject to be able to process, and I believe we will get into that. But in respect to special data, you would need consent, and the law does not give any exceptions, unlike ordinary personal data, where you can go ahead and process even where you don't obtain the consent. Children's data is considered as special data, and so children under parental control or parental guidance would, you cannot go ahead and process their data without obtaining the consent of the parent who that child is under. And so the key difference is that for special personal data, you would need the consent of the data subject. If it's a child, you need the consent of the parent. But for ordinary personal data or just personal data, there are instances where you can go ahead and process the personal data without obtaining the consent of the data subject.
Thank you so much, Patricia. So the situation is very similar under the Protection of Personal Information Act here in South Africa. So we get what I call ordinary personal information, or simply personal information. You call it personal data, and then special personal information. With our ordinary personal information, the key difference is there are lots of lawful reasons or lawful justifications to process that information. And one that we can rely on quite often would be it is in the legitimate interests of the responsible party, or it's necessary to protect the legitimate interests of a third party, or it protects the legitimate interests of the data subject, or we're giving effect to a contract, or there's a law that requires us to process the information. So consent is one of the reasons why we can process our ordinary personal information, but that certainly is not the only justification to process that information. The bar is set higher when it comes to information of children and information or special personal information. So very similar. It is more stringent, but unlike the law in Ghana, you don't need the consent. We do have some other reasons to process that information. For example, giving effect to a right or an obligation under law, but it's quite difficult to process that information without consent. Yisha and then Rahima, I just want to clarify with you. So then ordinary personal information, Rahima, and I know you don't have the big difference between ordinary the treatment of ordinary personal information and special personal information in Uganda. But I just want to clarify, in your jurisdictions, do you need consent to process your ordinary personal data that is not classified as special personal information, or do you have those type of legitimate interest exceptions as well? Aisha, I'm going to hand over to you first to tell us about Mauritius, and then you, Rahima, to tell us about Uganda.
Thanks, Ira. In Mauritius, I think consent is only one of the many bases for processing of ordinary personal data. So, for example, if you have to perform under contract to which the data subject is a party, you can process that personal data without specific express consent of the data subject. Similarly, if you have any legal obligation to which, as a controller, you're subject to, you can process that data, and you also have other bases such as you have to protect the vital interest of the data subject or any other person, or if you have to perform a task which is in public interest, or for the exercise of an official authority which is vested in the controller. So you do have a few other exceptions. So even, for example, if you have to, for the purposes of historical, statistical, or scientific research, you need to process some data, you're actually allowed to do that. And if you have the legitimate interest tests that you have to carry out, and if it is warranted, it will be allowed. However, if the processing is unwarranted and it will harm or prejudice the rights or freedoms of the data subject, then it will not be allowed. So the controller is actually expected to carry out a legitimate interest assessment in order to decide whether it has the right to actually process the data in the absence of the consent of the data subject.
So is there a statutory requirement to do that legitimate interest assessment? Because in South Africa, there's no statutory requirement, but we have to look at international standards. And of course, you should be doing one, but there's not a specific legislative requirement. So under the Mauritian law, is it mandatory?
So it doesn't specifically speak of an assessment, but it does say that you have to assess the legitimate interest. So this is the in terms of how it should be carried out. The data subject has got some rights that you need to balance out against the rights of the controller. So it takes the normal form in terms of the international standards.
And it's also quite interesting where you speak about the vital interests of the data subject and public interest. It sounds like your language is closer aligned to the old Data Protection Directive and the GDPR compared to the language of POPI, where we speak of legitimate interests of the data subject as well. So very interesting. Rahima.
Yes, so consent is not always required. It's actually just one of the about 6 other legal bases upon which you can justify a collection or processing of personal data. So you can collect if the collection is authorized by law. Public authorities, of course, are permitted to collect personal data because they require this to discharge their public functions. Collection is also permissible if it relates to the performance of a contract by the data subject. And I know that this is one of those justifications that employers usually rely on when they're doing processing and collecting activities. Then, of course, for medical purposes, and then you can also collect as a data controller or processor. If you're required to comply with the legal obligation, then that can also be relied on as a justification to collect and process data. So we have about 6 legal bases. I think the important thing when you're doing that processing and collecting is to ensure that it's justifiable, or you can point to one of these many legal bases to justify your collection and processing activities. Then, of course, the legitimate interest point is also another one that you can rely on.
Thank you so much. What did I want to say? I just forgot my point. But anyway, so let's move on to transport transfers of personal information. And as far as transport transfers of personal information is concerned, it is, of course, very, very important if you do enter into transport transfer agreements to take all these nuances in our different laws into consideration. We, for example, see if we have transport transfer agreements that we have to change the definition of personal data or data subject for the South African context, where we also recognize juristic persons. And of course, we need to check whether special personal information has got a different definition. So very important if you do deal with transport or transfer agreements, just to take into consideration that these terms have different nuances in the various jurisdictions. As far as South Africa is concerned, POPI doesn't have specific data localization requirements, so the data doesn't have to be housed in South Africa. But if personal information is sent by a responsible party out of the Republic, then they must comply with a certain safeguard as listed in section 72 of POPI, and that could be the data subject's consent. It doesn't have to be the data subject's consent. We can also send information, for example, trans-border, if we're sending it to a country with adequate data protection laws. Now, what is interesting here is that no country has got adequate data protection laws when it comes to juristic person information. So your transport transfer agreements, if you are dealing with South Africa, please remember we cannot rely on adequacy for juristic person data sent out of South Africa without entering into some sort of binding agreement or binding corporate rules for the recipient of that data. So very important to keep that in mind as far as transport-border transfers are concerned. And I finally remembered my point that I've so embarrassingly forgot. I wanted to mention that consent has got a specific definition as well in our law, and I suspect in your legislation as well. So consent, it must be voluntary, specific, informed, and importantly, an expression of will. So our data subject needs to do something to signify that they consent, and the consent, they must know exactly what they're consenting to. So my questions to you next would be, are there data localization requirements in your law? Are there transport-border transfer restrictions in your law? And just to get back to the question I had forgotten, is there a special definition for consent in your law? And Rahima, I'm going to turn to you first.
Okay, yeah. Sorry, yeah, so let me just cover the consent, the definition of consent first, because I think it ties to the previous point that we were discussing. So under the DPPA, consent must be freely given. It's got to be specific. It's got to be informed. It's got to be unambiguous. And there must be a statement or an affirmative action by the data subject that they actually agree to you processing this data. So it's actually very strictly defined. And I think the takeaway there is that if you're relying on consent, you have to be very careful that you check off all these boxes before you, I mean, otherwise you're going to expose yourself to, claims for breach. So that's broadly speaking, the definition of consent. And then when it comes to your point on data localization, there's no requirement that data must be, stored or kept in Uganda. So we don't have any data localization requirements. When it comes to, what then is the standard if you're transferring data out of Uganda? So 2 points. The first, of course, is consent. You can do it with the consent of the data subject. Or secondly, the data collector or data processor must ensure that the third country to which they're transferring this data has in place adequate measures that are at least equivalent to the protections that are provided under the DPPA. Now, this is on a self-assessment basis. So our data protection office has not published a list of countries that have in place adequate measures. So it's left to the data collector or data processor to make a self-assessment as to whether the country to which they're transferring data has in place adequate measures. The only requirement is that at the point of registration, you're required to sign an undertaking which you submit to the protection office to undertake that if I'm to transfer data out of Uganda, I will ensure that the country to which I'm transferring will protect the data in the same way that the DPPA protects the data. I think that's basically it for that transferring data requirements.
Thank you, Rahima. Ayesha, over to you to tell us about Mauritius, please.
We have an identical consent definition to what Rahima has described. It has to be a clear affirmative action, freely given, informed, and ambiguous, where the person actually signifies his agreement to his personal data being processed. So it has to be something that is freely given. It cannot be, you cannot assume that someone has given consent. It has to be a clear affirmative action that the data subject takes. In terms of data localization, we do not have data localization requirements that mandate personal data to be stored only within the territorial limits of Mauritius. However, our law does provide for transfer of personal data to be done in line with the required safeguards imposed by the data protection officer. So just like for the basis for consent, we do not have, consent is not the only basis for the cross-border transfer personal data. So the controller can actually demonstrate that he has got the required safeguards in place to protect the personal data being transferred. This can be done by way of ensuring that the law have got comparable measures. It can be done in terms of ensuring that there is a proper agreement in place with the required clauses for transfer to safeguard the personal data being transferred. In cases where you do not have the appropriate safeguards, the specific consent of the data subject is required. But if the controller deems that the transfer is actually essential, is necessary for the performance of the contract, for protecting the rights of the data subject, or is in public interest, for example, the controller can actually do that. But again, it goes back to the compelling legitimate interest of the controller that needs to be balanced out against the data subject rights. And it has to be on the condition that it is not a repetitive transfer and it only affects a limited number of data subjects, and you have carried out a proper risk assessment, which has to be provided to the Data Protection Commissioner in Mauritius. That said, you might not always need the consent, the approval of the Data Protection Commissioner. However, the Commissioner has got the authority to require proof of the effectiveness of all the safeguards and the legitimate interest assessment that you have carried out. And it can, on that basis, decide whether it wishes to prohibit, suspend, or impose conditions to the transfer of data outside of Mauritius in order to protect the rights and freedoms of the data subject.
So, Ayesha, I just want to clarify. So you have to basically notify the Data Protection Commissioner, and then they can suspend or stop the transfer, but you don't need to get a prior authorization or permission to send the information out of Mauritius. Is that correct?
That's correct. So you have
Perfect.
specific cases where you have to notify of a transfer. There is no specific requirement for approval, and the law is quite unclear on it. But to be on the safe side, we always recommend to our clients to send a notification and provide assurance in terms of the safeguards and the legitimate interest assessment having been carried out, just to reassure the commissioner that all the steps have been taken to protect the personal data being transferred cross-border.
How far do you go with that? Would that pertain to an email, including personal information, or is it more if you have to transfer information to be stored in a cloud abroad? Where do you draw the line?
So in terms of your application, already at the time of application form, like when you're doing your registration, you already provide a list of countries where you know you will regularly be transferring data. So this is kind of, we call it the blanket kind of approval. However, if you have a new project that is coming, you will of course carry out the data protection impact assessment. And on that basis, where you identify there is a high risk, you would write, and this can take the form of an email, because we have been reaching out to the Data Protection Office for guidance by email, and they usually respond by email. But it's always up to you if you want to write a formal letter, just to ensure there is proper documentation of those. But an email is totally acceptable.
Thank you so much. Handing over to you, Patricia.
Thank you, Era. So under Ghanaian law, there are no data localization requirements. And when it comes to transfer of data outside Ghana, it's fairly flexible. It's not as stringent as we have under Mauritian law. So what you're supposed to do as a data controller is to inform the Data Protection Commission at the time of registration that you intend to transfer personal data outside of the jurisdiction. You also be required to name the jurisdictions where the data will be transferred. You also have to inform the data subjects and get their consent. But as Ayesha said, there are instances where you do not have to get the consent because maybe the data subjects have signed a contract, or your transfer is required by law, or is in the legitimate interest of the data subject, or you, the data controller, and other further examples. And so once you get the consent, or if you don't need the consent because you have all these other exceptions or justifications that I've mentioned, you can go ahead and transfer the data outside Ghana. But a key thing you would need is that there has to be a written agreement between you and the data processor. So you realize that under our law, all the requirement to register, the regulation, everything is on the data controller and not the data processor. The Data Protection Commission does not really care much about the data processor. The focus is on the data controller. So you have to have an agreement as a data controller with a third-party processor. And under that agreement, and just to mention that we don't have a standard data processing agreement. Any widely accepted data processing agreement is acceptable, but you have to have an undertaking in there that the third-party data processor would maintain the integrity and security of the personal data that you're transferring to him or her. How the Commission is able to determine that the processor is going to maintain the security and integrity of the personal data is another question. But at least you have to have that agreement on hand. So if the Commission decides to conduct some sort of inspection, you can show them that, look, I have this agreement with the data processor, and the data processor has undertaken to maintain the integrity of the personal data. So in terms of data transfer, these are the key things that are required under law. We don't have any other requirements when it comes to the transfer of data.
Thank you so much, Patricia. And there, I just want to note, and I have mentioned it already, in some instances in South Africa, you need prior authorization before you send information out of South Africa. And that is when you send special personal information or information of children out of South Africa, and you're sending it to a recipient in a country without adequate data protection laws, or you haven't ensured proper safeguards for that data in terms of an agreement or binding corporate rules. But Patricia, what you were talking about regarding the agreement between the controller and the processor ties very nicely in with our next topic, and probably, given the time, will probably be our last topic, and that is everybody's worst nightmare, a data breach. And a survey has shown that there are two types of companies: those who know that they've had a data breach and those who don't know that they've had a data breach. Now, the data breach provisions in terms of the South African Protection of Personal Information Act are very, very strict. And in terms of our legislation, if you have reasonable grounds to believe that personal information was accessed or acquired by an unauthorized third party, then you have to notify, subject to limited exceptions, the data subjects and the information regulator. In practice, this is a horrible provision because it doesn't have a threshold for notification. So under the GDPR, for example, you only have to notify if there's a substantial likelihood that it will cause harm to individuals. In South Africa, every single data breach is notifiable. And it goes back to, I think I said to you, Aisha, where do you draw the line? You know, there is no line to be drawn as far as POPI is concerned. Likewise, with the law in Ghana, there must be an agreement between what we call the operator and the responsible party. And our law also doesn't care much about the operator. If there's a data breach, it is the responsible party's problem. And that is why you must make sure that you've got a proper agreement in place, and you want to include warranties and indemnities for data breaches, because POPI is not going to help the responsible party vis-a-vis the operator if there is a data breach. Patricia, back to you to just tell us more about the regulation of data breaches in Ghana.
So very similar to South African law era, where there's no specific time frame within which to notify the commission when there's a data breach. It just says as soon as reasonably practicable, and as soon as reasonably practicable may vary. Whereas under the GDPR and other jurisdictions, there's a specific time frame of 72 hours within which to report the breach. We don't have that under Ghanaian law. So in some of the data breaches that we have had to inform the commission, the Data Protection Commission about, the timelines vary. We've gone maybe a month after the data breach has occurred, 2 months after the data breach has occurred, because there's no specific timeline. And if there was some guidance on it, it will be helpful for us so that we can inform our clients that, look, you have to inform the commission within this specific time. But also it helps the clients if there's no specific timeline. It helps the clients to be able to put themselves together well before they inform the data protection commission. So that's it in relation to breach. There are certain actions that the commission can take when there's a breach, such as issuing an enforcement notice, and they can serve that on the data controller, so that the data controller will take certain steps or refrain from taking certain steps. There are also some compensation requirements, so that if an individual there's some distress caused to the individual, or there's some damage, that individual is entitled to some form of compensation under the law when there's a breach. These are the two key things I would like to highlight when it comes to data breach under Ghanaian law.
Thank you. And Ayesha, in no more than a minute, can you give us a crash course on data breaches in Mauritius, and then Rahima, in a minute, the situation in Uganda, please?
Okay, so 1 minute crash course. I'm not sure it can be done, but let's try. So in our law, we do have this obligation to report a personal data breach to the Data Protection Commissioner, and the wording under the law is not later than 72 hours after becoming aware of it. However, it makes a distinction between the risk to the rights and freedoms of the individual, which are deemed to be high risk. In such cases, we have to also inform the data subject of the breach that has happened. And if we have a notification that needs to be done to the data subject, that notification is the need is to actually do it in a clear, plain language, explaining the breach and providing the information in terms of how the data controller intends to mitigate the adverse effect of the loss of data or unlawful disclosure of that data. But the law also provides for exceptions in terms of if a data controller cannot actually make a notification to the Data Protection Commissioner, he should actually explain why there was a delay and what was the reason behind the delay, just to be able to justify making a notification outside the 72 hours required. When the Data Protection Commissioner is in the presence of a personal data breach notification, he can decide to issue an enforcement notice to tell the data controller that to actually take some remedial steps, and within what period those remedial steps need to be taken. And if there is a failure on the side of the data controller to take those steps, then in that case, the Data Protection Commissioner can actually refer the matter for prosecution to authorities in Mauritius.
Thank you so much, Ayesha. Rahima, I'm going to hand over to you. And once you have discussed it, Celia, then we'll hand over to you for the closing. Thank you so much.
Thanks, Ira. So the requirement in Uganda is to make an immediate notification when the data processor and controller, and maybe just to mention that unlike South Africa and Ghana, the focus of our law is actually on all the people in the process of collection, and so the DPP catches a collector, a controller, and a processor. So all these obligations are actually imposed on all of these people in their own capacities, which is different from Ghana and South Africa, where the focus, I think, is just on the operator. But just to go back to the point about the data breach, so the requirement is to make an immediate notification if the controller or the processor has a belief that personal data has been compromised. So I think just like South Africa, we don't have a threshold. And also I think the other problem is this immediate notification and the challenges around when you're making the notification, there's a requirement for you to, literally give a report around what exactly has happened, what remedial steps you put in place, who has been impacted, which data subjects have been impacted by this data breach. So you'll see that this whole requirement about immediate, and then exactly the information that feeds into the report that you need to make to the data subject is a bit of a misalignment, but that's the provision of the law. Then when it comes to notifying the data subjects, at that point, there's no requirement to notify the data subject. So once you've made the report to the PDPO, it then makes an assessment of the information that's been provided. And then it's the PDPO that then makes a call as to where, what next, what are the next steps in terms of how do we manage this breach. So I think broadly speaking, I say that we're out of time. Broadly speaking, that's how data security breaches are dealt with under the BPPA. Thank you.
Thanks, Rima, and thanks to all of our panelists. I think all that remains for me is to say thank you very much. I found it very interesting, not being a data protection specialist myself, and hopefully our attendees all did. So if you have any questions or need assistance with data protection, please feel free to reach out to any one of the speakers or to your key contact at ENS. We'll refer you to the relevant specialist. But yeah, other than that, thank you so much for attending our session, and look out for the invite to the next session. Thank you very much.
Thanks so much, Celia, and everybody. Bye-bye.
Thank you.
Bye.
Thank you. Bye-bye. It's 10.